Welcome to another episode of Marketing Tips for Doctors. I'm your host, Dr. Barbara Hales. Today, we have with us Andrew Contiguglia,
Contiguglia.
And he is a seasoned business attorney and founder of the Contiguglia Law Firm, PC.
Excellent. That's right.
Yeah, with nearly 30 years of legal experience. His business focuses on business law, corporate law, complex litigation, and risk and crisis management. He and his team are dedicated to assisting startups, entrepreneurs, and established businesses in navigating legal challenges and ensuring their success in compliance with the law and brand management. He is the author of Don't Skip the Legal Startup Guide for Business Owners and Entrepreneurs, and host of the Don't Skip the Legal podcast and YouTube channel. For more insights and comprehensive legal solutions tailored to your needs, visit the Contiguglia.
There you go.
We'll get back to that later. But I think that trying to pronounce it is just going to make you, as well as me, remember the name all the more.
I know. And listen, you are in a hefty group of really great people who couldn't pronounce my name. But now that you know, when you see it and you put your eyes on it, you're like, oh yeah, now Contiguglia. Once you learn it, it's easy.
Yeah. I'm just going to practice it tonight when I'm going to sleep.
That's right.
Okay, so the overview of key legal considerations doctors must be aware of when marketing their practices must be pretty hefty. What is it that you see in that?
That's a great question, and I'm glad you brought it up because the industry for doctors, I think, is a lot like the industry for lawyers. And we were kind of talking about this before we started recording. We've got those client confidentiality, or in your case, patient confidentiality issues that you need to manage and deal with. There are other ethical considerations. And, the hardest part about being a doctor or a lawyer, I think, is you've got these governing bodies who really like to toy with you and play with whether they're going to take your license to be a doctor away. And you get a grievance or something in that respect, you have to defend that. So I find myself as a lawyer really tiptoeing a lot in certain areas. And I can imagine that your listeners and doctors are in a similar situation when it comes to, managing their practices and trying to, promote their businesses all at the same time. I grew up a doctor's son, so I'm familiar with the way it was. My father was a nephrologist and owned a kidney dialysis unit here in Colorado for, decades. And I remember growing up and going in rounds with him and meeting his, patients and stuff like that. I don't think you could do that today. I think with some of the requirements, that were there. But I also know that they never did any marketing. It was always like people show up, they go to their general practitioner and they get a referral, go see Dr. Contiguglia, my father, not me, for, you got kidney problems, go do that kind of thing. And so I never really saw that in the buildup of his business over the years that, I sort of watched him do that. But over the years as a lawyer, doing this now 30 years, I love the marketing space. And it's given me this opportunity to work with companies. I have worked with dentists, I have worked with medical doctors, I've worked with other law firms to really help them navigate some of the issues that come up in the marketing space. Now, you're niched in real deep when it comes to doctors, but some of these issues when it comes to the legal issues of marketing, I think could extend to anybody. But but as we discuss this in the form of, how doctors are going to need to manage this, I think it'll be applicable to pretty much anybody who is looking at marketing and, working with their business. So I think the first thing really is issues with like copyright and trademark. And that's a big piece of what we do in marketing. Here you are at, looking at your copyright. Imagine you created some really cool brand or logo, a drawing, some story if you're blogging, and you want to make sure that this creation of yours is not used without your permission. So all of these doctor offices, these doctors, they might want to protect it legally. We're getting away from this idea of building businesses around our own name. Now, I'll tell you, I'm old school, Contiguglia Law Firm. Come on, I'm in my own name. But as we all know, in the advertising and the marketing business, our life in terms of succession, like what comes after Contiguglia, we need to think about the next person. And so in the medical field, I've noticed you get like North Denver Radiology. And so there's these real generic names that sort of come up for the doctors to sort of consider what's going to happen when I sell my practice later on down the line. What branding or what intellectual property can I create as a business owner outside of being a doctor? Can I create because I'm trying to build a business in addition to saving lives? So looking at you, go ahead.
Do you find that artificial intelligence now is a threat towards trademarking?
I don't think it is, and I'll tell you why. The interesting thing about the Copyright Office and the Trademark Office is, when it comes to copywriting things, we're talking about creations of creative works, things that like books, stories, music, songs, TV shows, paintings, drawings, that kind of thing. The Copyright Office now has a component when you apply for a copyright about whether you used artificial intelligence in the creation of the item. And if you have, you won't get a copyright on it. So, one of the requirements under the copyright laws is that the items that you are looking to copyright must be human generated.
How can
There
they
was,
tell?
I'm sorry?
How can they tell?
You're right. Somebody could lie. Somebody could certainly lie under the penalties of perjury when they apply for a copyright and say that they created this. If it turns out later on to prove that it's proven that they didn't really create it, that it was a work of artificial intelligence, they would not have the copyright protections they're hoping to protect. And so they don't have enforceability. They don't have the opportunity for fines and costs and attorney's fees when it comes to enforcing those things. Now, my personal opinion on that subject is going to be, I think the Copyright Office is going to have to change in the way it evaluates copyrights. We don't have a lot of litigation in the area. We don't have the Copyright Office rejecting people for artificially made logos and things like that yet. They haven't gone to the court system to be litigated about how much effort did Barbara Hales put into the creation of the prompt that would then create the image that you are now seeing today? Because there is a bit of human interaction when it comes to artificial intelligence and the creation of creative items, whatever it might be. So I think we're going to see some transition from a legal standpoint in looking at it in that standpoint. So we've got that. When it comes to trademarking is a little bit different. Think of a trademark as your badge of identity for your brand. Hales Marketing may create enough of notoriety and have enough foundation in the marketing community that you have developed your own identity. Think Michael Kors in the fashion industry, somebody's name that has been into that. But you're looking when it comes to trademarking, things like company names, logos, slogans, product names, those types of things, you still have to argue are your brand identity before the trademark office, which is different than the copyright office, is going to issue you the trademark. So creating a logo for your business, coming up with a catchy slogan, a trademark is going to ensure that you can use that logo, you can use that slogan in the marketplace. So think of trademarking as your brand identity versus a copyright as sort of your shield or the protection of the things that you create.
What steps do you recommend for physicians to register and protect the trademarks for medical practices, ensuring the practice name, logo, and the slogan, and that they're legally secured?
Yeah, that's a great question. And a lot of it comes down to how much have you used those items, that intellectual property, in your community as a business. So when you file for a trademark, you can take one of two approaches to it. You can take what's referred to as a usage trademark, meaning I'm applying for my trademark today because I am using it today. I have, used it in the community. It is a component of my brand identity. And then it's up to you to prove to the trademark office that you actually have the brand identity that you're looking to trademark. It has to be unique. It has to be, authoritative in your industry. There's a number of different factors to be considered when it comes to your trademark. So that's the first way of doing it. Establish it first, then trademark it second. That's number one. Number two is you can file what's called an intent to use a trademark. So maybe you come up with an idea of like Hales marketing, it's the sky's the limit, and you want to go ahead and identify that as your trademark slogan. But you just came up with it today. You want to make sure nobody else out there named Hales is going to, take your slogan. So you might file what's called an intent to use with the trademark office to sort of hold your place in line.
Mhm.
And then over the next 6 months, you'll be allowed to develop your trademark and your brand around that slogan into the future. And then you could submit it after 6 months to say, hey, trademark office, we've done it. And they'll make a decision based on what you've done. If you haven't done it by that point, you can extend it an additional 6 months, and you can do that up to 3 years. So you'll get 246 extensions of an intent to use before the trademark office is going to say, yeah, we're not going to hold this spot for you any longer. You got to go. Now, that seems like it might be an easy thing to do, but every time you ask for that extension, it's going to cost you, I think the filing fee for that is $375, but don't quote me on that. So you're doing that, 6 times, that can be expensive.
What happens if you've gotten the trademark, but you don't renew it through a lack of, being aware
Yeah,
after
that's
like 5 or 6 years?
Yeah, so that's a good question. So your trademark is going to be valid, and you have an obligation to enforce it. So when you are using it, if you see anybody infringing on it, you have an obligation to actually go and tell people you can't use it. You have an obligation to bring lawsuits against them or apply cease and desists, because if you don't do those things, you're going to lose your brand identity. And that's the thing. And the nice thing is with the trademark office, they tell you when your mark is starting to expire and give you an opportunity to renew it and things like that. So that's always a good opportunity.
What's the difference between trademarking and registering?
For a copyright?
Yeah.
Okay, so that's a great question. So think of a copyright being for creative works, things like artwork, writing, a logo that you create for yourself, something artistic, the blogs you write, excuse me, the content up on your website. That's going to be covered by copyright. Trademarks, on the other hand, are going to be things that are brand identifiers, things like your logo or name, product names as it comes to your particular industry. Duration also, I think, is a big difference. Copyright protection is for a set period of time, and it's usually the life of the creators plus, if I remember correctly, it's 75 years. And with a trademark, that can last forever with proper use and renewal, requirements going on. If you remember, there's a few things that are coming up out of copyright protection. You have Winnie the Pooh came out of copyright protection, and so now it's going to be part of, everybody can go and make whatever kind of Winnie the Pooh this or Winnie the Pooh that you want. Disney, that's gone. Same thing with Mickey Mouse. That is coming out and coming into the public domain too. So you're going to see some very interesting creative works now coming out with these new ideas with that. The last thing also I think is between the two is really the purpose. Copyright stops people from copying your creative works without your permission, and trademarks prevent other people from using your brand's identity, so your name or your logo, in a way that could confuse customers. So think of trademarks as a way to identify and brand yourself independently from everyone else to make sure that nobody else can be confused with you, versus copyright, which is you want to protect the things that you have created.
Let's move over for a moment to social media. And, it's something that we're all on, some more than others, to try to get our name out and name recognition. What are some legal do's and don'ts for doctors using social media to market their services? including patient privacy and advertising guidelines.
I think that
As long as you're not using a patient name in what you do, are there other things that we should be looking out for?
absolutely. And I want to caveat this response with everything. Everybody is different. Every case is going to be different. So what one doctor does is not going to be dispositive of what another doctor does in the same lane. I think nowadays with advertising regulations, the Federal Trade Commission really governs what people put out there into the world. And they are starting to crack down on social media influencers and people in the social media space about how those individuals are advertising their services or advertising products. So I could certainly see a situation with a doctor being sponsored by, I'm using that term loosely, by a company that wants to promote a stethoscope, let's say. And so the doctor's going to go, I can hear everything with my over the ear stethoscope. And, here you go. Everybody should go out and buy one. The link is in my bio. And yes, I get a $25 commission for every time you buy one of those. I could totally see a doctor wanting to get into sort of that brand identity and use things in the areas of nutrition nowadays. I think you get a lot of that with supplements. There's a lot going on with that. I have yet to see it in the area of pharmaceuticals and things like that, but I certainly see that that could be something down there in the future. So the reality here is when it comes to the Federal Trade Commission and when you are promoting a product of somebody else's, you have an obligation, a legal obligation, not an ethical one, but a legal one, to notify your consumers or the people who are observing your broadcast that you have a stake in what you are promoting, whether
Mhm.
you're going to get a kickback from a sale, whether it was given to you for free, whether you have a stake in the company that is trying to promote those things. That I think is something that the FTC is going to come down and really crack down on you in that process. There have been some really high level influencers who have been busted by the FTC for promoting brands and not telling people that they are affiliated with that brand in some form or fashion, that they're either getting a kickback, a royalty, or something like that. So I think it's really important. Any doctor who is advertising for somebody else to promote a product, absolutely, you got to give that up and say, listen, I have a stake in what I'm selling you. Because the concept of truth in advertising really needs to be pushed on the end consumer. They need to know that you're biased in what you are promoting to me. And so as a result of that, I need to know that I could be buying something that could help you. Now, the opposite of that, I don't think is true. Now, there's sort of a divided lawyer opinion about this, which is if I'm not getting paid, if I'm not getting endorsed, it just so happens, hey, I went to the store today and I picked up this thermometer. I have to tell you, this is the most accurate thermometer I've ever used in my medical practice. It doesn't matter what hole you stick it in, you're going to get the best. You're going to get the best reading of the body temperature no matter what. Now, if I'm not getting paid by that thermometer company, but I'm telling you what I like about it, I don't think I have an obligation to say I'm not getting paid. But if the thermometer company comes to me and says, we'd really like you to promote this and we'll give you a penny for every one of these that gets sold, now I've got an obligation to do that. So I think that space is really the big piece of that. And also you got truthfulness. I think that's a huge part of it. Every advertisement that you're bringing up must be truthful, shouldn't be misleading. That is not only akin to the products that you're promoting, but it's also about the nature of your business. I don't think, well, doctors may be a little bit different, but in the legal community, unless I'm in a jurisdiction that allows for me to say that I quote unquote specialize in business law, I'm not allowed to promote that. I'm not allowed to say I'm a specialist. It may be different in the medical field. I see specialists around all the time. So I think every state is going to have a different requirement about what you can and cannot do to tell people about your specialty, or whether you just say, I'm an orthopedic surgeon, or I'm an orthopedic surgeon who specializes in hip replacements. That would be something, a little bit different. I think testimonials creates some issues. I think we've got patients, you know, telling people about their experience with you. And I think that it's very important when a doctor uses testimonials from one of their patients, that they get their consent and a waiver of any confidentiality in the process of doing that. I think you need to put a limitation on what you can and cannot use any of those testimonials for. Hey, Barbara, I would love it if you would give me a testimonial about the cast I put on your arm the other day. That would be awesome. Understand, I'm only going to use it on my website in this section called testimonials. I'm not going to use it anywhere else, because you want to make sure that the relationship with your patient is protected. Because the last thing that you want to see is that I've now taken that interview, I've spliced it up, and now I've put it into different areas, and it's now on a YouTube channel for something completely unrelated. And it's just you as a soundbite with, best cast ever, whatever that is, that does or doesn't necessarily agree with what you consented for me to use your imagery for. So I think you need to really play that one, on a case by case basis when it comes to, your patients and that. Comparative advertising, I think that many instances when you're trying to compare yourself to, Dr. Jones down the street, when Dr. Hales is the best hip doctor, you got to be careful about bad mathing, Dr. Jones down the street for botching, a hip replacement at some point. And if there's any Dr. Jones out there, I completely made this up. This is not about you at all.
There are a lot
You
of Dr.
touched,
Jones out
you touched, I don't want to upset anybody. I'm making names up and I'm pulling them off my screen as I'm sort of going through my notes. Um, I think, you and I touched briefly on patient privacy, HIPAA compliance. I think that's pretty much a no-brainer when it comes to that kind of thing. Um, I do also think that nowadays, where doctors can really kind of see themselves into, the Dr. Oz, Dr. Phil celebrity space, which I can't imagine any doctor isn't hoping they get into. You're looking at your likeness and the things that are important to you and your business, and being able to present their qualifications and credentials to other people. So you need to make sure that, you're properly licensed. If you have a certain brand, that you're sharing licenses appropriately. If you're using content from someplace else, that you're properly licensed. I'll tell you a horror story about that in a minute. So remind me in about 2 minutes about stock photos and things like that on websites. I think that's a big piece of it. I think, accurate representations of your qualifications, making sure that your information on your website is up to date, those things, credentials, keeping up to date. If you lost a credential somewhere or acquired new ones, making sure that any of those changes are properly reflected in your marketing materials. Again, this all comes down to truth in advertising. The last thing you want is somebody, a patient coming to you because they expected that you were still doing hip surgeries, because that's up on your website as something you do, but the last one you did was 25 years ago, and here we are, the complete methodology and process of doing a hip replacement is different than it was 25 years ago. um, so you need to sort of evaluate those. And I think also the scope of your practice, accurately representing the scope of your services and what you're legally allowed to provide, making sure that you're niched down and not breaking anything in that respect. When it comes to doctors utilizing marketing services, so I'm going to throw you into the mix on this. I did some research on you. You're a content creator, so you like to help create, content for doctors, and I'm assuming it puts you create things they put on their blog, they put on their website. You help them create, dialogue that they're promoting out there. I haven't reviewed your contract, but I at some point might want to, because I'm curious about, after you create it, who owns it? Because this gets back to that copyright question we brought up at the very beginning, where the copyright stands with the person who created it. So, Barbara, if I hire you to create the best medical blog in the world, and you've written some great stuff that I put up on my website, and I go to try and copyright it, that doesn't belong to me. It belongs to you. And you have given me, a limited opportunity to use it on my website. So that really depends on the nature of your contract with me and what services you're providing to me. And I think that doctors really need to be careful about how much authority they want to give to marketing individuals, about how much stays in the hands of the marketing professional. I have run into problems with other lawyers who hire marketing groups that say, hey, we've got this bestpersonalinjurydenver.com that we'd love to, put all your stuff on. And you go, great. And you use their services. They take everything that you have and they build this beautiful website of, best personal injury lawyer denver.com. And now all your stuff is there and you're doing it, you're doing it, you're doing it. Everything's great. All of this brand, you're getting calls and calls and calls. And then all of a sudden you say, great, um, I'm out of the personal injury. I'm out of the personal injury business, or something else comes up. You get in a fight with your marketer because, God, that never happens, does it? Um, and now the marketing company is gone. And now you want all this content that you created. And the marketing company is going to go, no, that belongs to us. That was all proprietary from what we had created on your behalf. And that belongs to us. You don't get it. And now I have had calls from other lawyers, other business owners who are like, well, what happened? I mean, those images are of me. The content we created is of my practice area and all these things. What am I going to do? And I'm like, well, let's look at the contract. And unfortunately, these aren't work for hire contracts, because when I hire you, I want to make sure that maintain the ownership of the things that you create on my behalf. That's the whole concept of work for hire contracts. But if that's not there, guess what? You've lost all of that. And in many instances, you see these web designers or other marketing companies holding your content hostage until you either pay them a fee, pay them, well, we created it's $25,000 worth of stuff that we created. So pay us $25,000 and we'll give it all to you. And now you got to decide, well, what's my brand worth and what was there? What's really there? So like if you look at my website at contiguglia.com, everything in there is original, with the exception of the things on the blogs, which we get through stock services. But all my photos and everything I take. I want to make sure that I have ownership in everything that I create. So when I use marketing companies, and I use content creation companies, I use people who help, edit my podcast. I have people who help, write my blogs and do web design and things like that. And in every one of those contracts, I make sure it says that I, Andy Contiguglia and the Contiguglia Law Firm, own anything that you create at the end of the day. I have yet to really get any pushback from anybody on that. But when marketers say, no, this is mine, I'm going to create, I'm like, great, goodbye. You're not the right person for me. So it doesn't matter. It doesn't matter under those circumstances. So I think that's an important piece. God, I've covered a lot in this. I haven't stopped talking. So I'll give you an opportunity to ask some more questions and follow up from all of this. I could talk for hours on this stuff. Clearly, I like it, right?
It's kind of amazing that lawyers themselves get caught in that quagmire. You would think of different specialties, but you wouldn't think that lawyers themselves would not check more into that.
It's funny because I represent a lawyer marketing company. And in my discussions with the owner of that company, we talk all the time because they also run a podcast. And one of the episodes of their podcast was those types of horror stories about companies holding the lawyer's content hostage to either get paid or, elbow out the lawyer out of that stuff. And I mean, think about all the energy and the time and everything that you put into building your brand. Think back to copyright and trademark from the very beginning. And now it's being thrown out the window and in the hands of somebody who you are in a legal dispute over. And, sometimes you have to sort of sit back and go, well, what's it going to cost me to recreate everything that I've just now created over the last 5 years? Um, and that can be expensive. And it may be enough where you could say, all right, here's what we'll do. Let's offer, and you can do this. I've gone to marketing companies and said, listen, I will get in a legal argument with you. I will sue you over this. Let's avoid it. My client's willing to pay you $10,000 for all this content. What the hell is it for you? Why do you care? Give me the content. What You can't use it for anything else, Barbara. If you're putting Andy Contiguglia for the Contiguglia Law Firm up in your marketing stuff, you can't use Andy Contiglia's face when you're doing John Doe's website on the exact same stuff. So the fact that you have all of Andy Contiguglia's mug and content and videos and everything in your possession has zero marketability for you unless you're going to try to generalize it. But then you always do have this opportunity to say, well, you don't have my permission to use my likeness in that context as whatever you're doing. So there are ways that you can protect yourself. Another one, I'm going to give you another horror story. God, I hate being the bearer of doom and gloom. I feel like a doctor. Um, but here's this. I have seen situations, and this happened. I had an in-house marketer for a while. She was great. I had to teach her about the legal issues when it came to marketing. And so she put together some great marketing material and she presented it to me. And she goes, well, what do you think of this? I said, listen, it's beautiful. I think it looks great. Like, but where did you get those images? Oh, I got them from, Google, Google image search. And I'm like, okay, you need to go find other images. I'm like, we are subscribed to Adobe Stock. Go to Adobe Stock, get your images from there. Well, why? Why? Because we don't own the rights to that. We don't have licensing to use those images. And I think people have this tendency, Barb, to think just because they can find it on the internet or if they type it into Google and it shows up in an image bank, that they have the right to use that. I had clients who got sued over it, and it's expensive. It's like $7,500 a violation. And if you're making money off of those, you have a responsibility then, if in a successful lawsuit against you, to pay anything that you might have received as a result of that. So copyright infringement can be a huge, huge problem for you if you're being dinged for that. So I always make sure that if I'm hiring a marketing company and they're creating content for me and they are going to pick your stock source for materials, that they're promising that they have the right to use it, that they're not stealing it from somebody who's later going to come back. That happened to me. I had, we call them copyright trolls. They're lawyers out there who love to go around and find people who are infringing on other people's trademarks. And they go around and they shake them down. They shake them down for, tens of thousands of dollars because they know, because they're going to come to you, Barb. They're going to go, hey, Barb, I went on your website and you have this image from my client. It's of a plant. This is based on a true story, but the names have been changed to protect the innocent. You have this plant on your website, and my client took a picture of that plant. That picture is copyrighted. You owe us for this. And we had to literally, they're like, so they walk through and they go, here's, it's been up on your website from our math 18 months. So that could be one infringement, 7,500 bucks. It could be multiple infringements depending on how it is operated. It was also to promote a product that my client was selling. So then there was revenue generated as a result of that image. And so you add all of these up, and these lawyers are very creative in the way that they, max everything out and they say, hey, if we have to sue you, we're coming after you for $350,000. And you go and you look at your client goes, I can't afford this $350,000. What should I do? We write back and we say, yep, here we go. What do you want? And they go, yeah, well, we would be happy to settle this for $7,500. You go to your client, you go, pay them the 7,500 bucks. They're like, what? What are you talking about? Listen, they have a claim. You didn't do what you were supposed to do. And by the way, that $7,500 is a fraction of what you're going to pay me to litigate this for you. So now you decide what the business, and these lawyers coming in there, they will file hundreds of these. And if they're getting 7,500 bucks per pop on each of these and they're filing 100 of them a year, do the math. That's 750K of like low hanging fruit in legal fees that you can get on these things. And they do that. So, in the case, I had somebody reach out to me for a picture I had up on my website. Now, I'm smart enough because I know that I go to a stock service and I am licensed, for those images. And so they tried to shake me down. I said, I'm sorry, but I have a licensing for this. They were like, well, we need you to prove it. I'm like, great, here you go. So I went through the process with Adobe. I am not a paid advertiser of Adobe. I use Adobe and I love it. And their stock services are awesome. I get no kickback from this. See, FTC now rolling back around. Um, But we've got now, I had to prove to them. I'm like, here you go. Here's the licensing and everything. They were like, great. Thank you. We appreciate it. Have a good day. And they were gone. That was it. Just proved it. And I think that becomes, I think, the most dangerous atmosphere for doctors to be playing in when they're not using their own original content. And then when they want to create their own content, they need to make sure that they retain ownership in that content after the photographer, the videographer, the blog writer, the content creator has produced it. And I think those are the biggest pieces of it.
I think that's so true. And in speaking about that, I just want to point out to the listeners, when you see that an image is royalty free, sometimes it could be royalty free for personal use and not commercial use.
Absolutely.
So there are all different ways that something is royalty free, and you have to make sure that you're getting it for the purpose that you are using it.
Absolutely. And I think that that's a really good distinction also. If I am putting up, a video that I created on YouTube for my own personal use, I can use YouTube's, laundry list of songs and sound bites and things like that that they have available to me as a creator. However, if I'm creating things for Barbara Hales and Barbara Hales marketing world, um, I may not be, the license may not allow me to use the license from YouTube that I create for you. Um, it would be your license that you would have to go get independently from me. Not only that, but I see people, marketing companies using the same image in more than one publication. I think that creates a problem. I think depending on the license, that could create a licensing violation that, the creator of that content could come after you for. And I think that anybody who is using a company needs to make sure that they are indemnified, meaning that in the event I'm sued and I have to pay something out, that I can get paid back by you for violating the law that I got blamed for. I think those indemnification provisions are important in every one of those contracts. So we want to make sure that the doctors are protected in that respect as they build that out.
Absolutely. Tell me, how does one structure agreements to ensure clarity on deliverables, which is something that we've been talking about, as well as confidentiality and dispute resolution?
Absolutely. I think those are that's great. And getting back to the marketing company that I represent, that legal marketing company, we have been working on their master services agreement for months now, and it has gone through a number of different variations. And I think the perspective of the information I'm about to give really depends on whether I'm representing you as the marketer and the creator versus the doctor who's entering into the agreement. It is my belief that, Barbara, if you're providing a marketing service to me, you should be providing the contract to me for my review, and that you should stand fast on the terms that you want. Hey, if you want Barbara Hales to do your creative marketing and do your content marketing, you got to agree to my terms. Hey, when people hire me, they have to agree to my terms. I'm sure every one of these doctors that listens to this podcast, every patient that comes in through the door has to agree to do things the way the doctor says. That's just the world we live in. I think it would be different if I'm providing you, oh yeah, Barbara, here, I'll provide you my marketing contract, and then you've got to agree to my terms. It doesn't always work out that way. So I think, I have seen horrible marketing contracts. I've seen ones that last forever. I see ones that you can't terminate. And I will say this, bad contracts are still binding. And without somebody going through your agreement with you. Like, I don't mind if you enter into a bad agreement, Barbara, but let's sit down and let me go through it with you so you know what you're getting yourself into. And at least we can discuss any way that you might be able to get out of this contract under what circumstances. Because you see these things where marketers hold websites hostage, they hold branding hostage, they hold images that they create hostage, all of these things. And you want to make sure, like, listen, you want to agree to this stuff, great, but understand what you're getting yourself into. And I think we're explaining it and walking through it with somebody who has the background in it, I think is going to be imperative and really helpful in the way that you look at hiring a marketing company. So I think that's the first thing. Um, what other terms should be in there? I think you need a term like, how are you going to get out of this? I think every contract should have a form of termination because, Barbara, I love you. You're great, but I might not want to work with you forever. There might be somebody else that I want to go work with. Or here's something that happens a lot. And I've run into this representing other marketing companies that have gone out and bought smaller marketing agencies in order to grow their companies. I've seen it where, company A says, we're going to go acquire company Z, and they go and they acquire company Z. And all the people who were working with company Z hate company A. And
Yeah.
so somebody comes in, Barbara, I have a contract with you. Company A comes in and buys your company. Um, I may not like working with those people. No, I am a true Barb believer. I'm working with Barbara and nobody else. How dare you do that? Now, of course, from a customer service standpoint, I hope you would talk to me about it before selling it, but it doesn't always work that way, especially in the marketing industry when you see transition after transition after transition, or you want to retire and your associate is now running your company. So we want to see those things, but I may not want to be around for that long and I might want to get out. So termination clauses.
Bring up an interesting thought, though,
Yeah.
because if a contract is with a certain company, then is it, if the company changes or the people that sign the contract change, doesn't that in and of itself make it less legally binding?
It doesn't change the legally binding nature of the agreement. So it really depends on the nature of the contract and the nature of the acquisition that happened. So let me walk through a situation with you. So let's say you want to buy marketing company B, and part of what you're buying are all the contracts that marketing company B has. So you're buying marketing company B, you work in Florida and East Coast. Marketing company B is all California doctors. You're like, what a great market for me to get into. I'm going to buy this agency up. Perfect. Now, one of the things that you need to look into when buying that other company is, are you buying just the assets of that company? Or are you also buying the stock of that company? Because if you're buying the stock of the company, nothing underneath the company changes because you're buying the ownership interest in the company. However, when you're buying just the assets of the company, it's customers, it's intellectual property, it's products, it's know-how and other foundational requirements, that may not be it. So when you're buying somebody's contracts, you need to make sure that the contract you're buying can be transferred to you. So we call that assignability. So is the contract assignable? If the contract is assignable, you don't have an issue with it because the owner is just going to transfer it to you. They're going to assign it. We do that through what's called an assignment and assumption agreement. And any contract, let me rephrase that. Any contract is transferable unless the contract prohibits transfer. So what that means is I can transfer any contract I have to you so long as the contract doesn't prohibit me from doing so. But you'll see that lawyers are smart. You might not think that, but we are sometimes. And we put in these non-assignability clauses for exactly this, because we want to make sure that you can't transfer your duties and your responsibilities to somebody else. And as a result of that, we want to make sure that we have an anti-assignment provision in there. So now, Barbara, if we're going to go buy all these contracts, guess what I have to do? I have to go to every one of those customers and I have to say, hey, Barbara is buying Company Z. She would love to continue to work with you. Let's meet. Will you agree to have her take over your contract? And most of the time they're like, yeah, that sounds great. I don't care. I just want marketing services. But sometimes you may say, no, we're not going to do that. And so, I've seen people get not pay enough attention to that and get dinged by that later on, where the client's like, yeah. And now, you went out and you bought, imagine this, you buy this company out in California, they have 1,000 customers that they're dealing with. And you're thinking to yourself, I'm buying 1,000 $100,000 contracts because each one of these contracts is $100,000 deal for me. And every one of these now is like, yeah, guess what? no, we don't agree to the assignment and we're out. And you've just now paid all of this money for a marketing company that now you can't use those contracts. Oh, I'm going to make it even worse. I represented, it's funny, I represented somebody, and this was actually in the medical area. He was a locum tenens guy, and he was buying up other locum companies around the country. And the different companies that he was talking about, I was giving you, yeah, and as I was saying earlier, I represented a company that was going out and buying other locum tenens companies. And one of the companies that he was purchasing had a number of different locum contracts in varying states around the country, and also like in, the Bahamas and Virgin Islands and things like that. And so my client was buying all of these other contracts that this other locums company had. And so I'm like, all right, well, let's take a look at the contracts that you're buying, because we need to know what we're buying. That's the asset you're buying, is all those contracts with all those other doctors. And he's like, all right. So we started getting copies of all the contracts that this other locums company was utilizing with all of its locums doctors. And every one of those contracts, I kid you not, there was probably about 15 or 16 of them, was different.
Oh, my.
Some of them had mandatory arbitration. Some of them had venue in California, meaning that's where you're going to sue. Some of them had, Virgin Islands um, law being applicable. Others had, Delaware law being applicable. It was a mess. Some of the contracts allowed for assignment. Some of the contracts did not allow for assignment. And so we were in this difficult position. I'm like advising my client, I'm like, do you really want to do this? I'm like, I don't think this is worth it. This is going to create more headaches for you later on down the line. And ultimately, my client's like, yeah, you're right. I don't want to do this. This is not worth it to me. Um, so he ended up backing out of the deal, but that's part of, what we do in due diligence when it comes to buying other companies, which, it's not a marketing issue for doctors, but I've represented a ton of doctors in selling their businesses and buying other businesses. I think it's a great way to, you know, when you're coming out of med school and your residency and fellowship and all, and you're looking to jump into, building a company, there you go. I mean, that was my dad's exit plan. He sold his nephrology practice and his dialysis unit to a very large Health One company, and retired very happily from that.
That's great. Let's shift our conversation a little bit to your book, which has
Yeah.
a very catchy title. If I were to buy your book, what kinds of things would I find in it?
Oh, it's really it's a guidebook, so there's nothing real fancy about it, and it really walks you through how to start and set up your business for success. Or if you are a current business owner, the book has in it like, things that you could think about, whether you should be hiring employees or what, or your workers should be classified as employees or independent contractors, walking you through some of those legal issues. So the way it's designed, it literally is from, hey, what choice of entity should I be? LLC, corporation, partnership, you pick it, all the way to, the end of that journey of selling your business. There have been some changes in the law that is going to go into my next edition here shortly, with beneficial ownership interests in companies. You've probably heard about that. You have now the Financial Crime Enforcement Network, FinCEN, FINCEN, requiring owners of businesses must register with FinCEN anybody who has a beneficial ownership interest in their company. Meaning, if they own 20% or more in a company, you have an obligation to put FinCEN on notice of your ownership interest in that company. Now, businesses that were in existence prior to January 1st, 2024, have until December 31st, 2024 to get this done. Businesses that were created after January 1st, 2024 have to get that done within 90 days of registering their business with their local Secretary of State's office. So that's a big one. The next big one is the Federal Trade Commission coming out and outlawing non-compete agreements pretty much across the board with very few exceptions. One of the exceptions being if I have a partner in my business and I buy you out, Barbara, I can put a non-compete on you to not compete because you were at the ownership or high level managerial level. But your typical employees, you can't. People who, lower level managers, you're not allowed to put non-competes. So if you had a sales rep working for you who was awesome, and you fire, you can't prohibit that person from going across the street to Andy Conaglia's marketing agency and competing against Barbara Hale's marketing agency. You just can't do that anymore. So this whole prohibition on non-competes, I think, is really important. It doesn't prohibit, people from putting non-solicitation agreements in place. So you can't call my clients, you can't work with my clients, you can't call my employees, that kind of thing. That you can still be protected. So those two big changes, I think, within the last year or so have really come down, and it just becomes one more box we have to check as we start helping people with their, the startup of their businesses or running and operating their companies down the line, and also making sure that those things have been done when they look to succeed from their business, whether it's selling it or transferring it to another person.
Well, I assume that we could buy your book on Amazon.
That's right. You can find it
Is
on
it
Amazon. Yep.
is it available on audio file as well?
Not yet. That is something I'm in the works, but it's on Kindle. I think you can even maybe Kindle read it. Your computer might read it to you. Might be boring. You don't get this much entertainment with a computer. Um, but you can buy it. You can buy it on hardback, or I'm sorry, paperback, and on Kindle. Also, if you go to don'tskipthelegal.com, you can get access to my podcast, which is the Don't Skip the Legal podcast. See how we're working on the trademarking and the branding? That's how this all fits in. You'll see my logos, which would be copyrighted. Also, you can check out, any of the videos that I've done on YouTube. I put a lot of those out too over the years, and been working on that. So that's where you can find me. And if you want to find me on any of the socials, you can find me at AJCESQ. So at AJCESQ. So find me at Twitter, Instagram, pick it. I'll be there.
Okay, so we're going to give our listeners 2 tips that they
Okay.
can implement right away.
All right.
What 2 tips would you like to leave them with?
That's a great question. I think the first tip would be pull your contracts and review them, because what I have found is many of these individuals sign these contracts, they don't know what they mean, or now that here we are, we've been chatting for about an hour or so. Now they have all this new insight and knowledge as to how to approach and view some of these things. But I think that they should look at their contracts now with this new light, and sort of critically evaluate whether these are the right deals for them to be in. That would be the very first thing. The second thing would be I would make sure that you have ownership of every image that you have on your website and that you use in your marketing protocol. I would do as much as you can to steer away from using any of the stores, or your stock photos and things like that. And I would create all original content. So hire somebody, make sure you retain the ownership interest, and create all new content from the beginning. It sounds like it's an ordeal, but break it down into time. Over time, you'll get it done pretty quickly.
Well, I think that the thought that would go through every listener's mind after listening to this podcast is, I need a lawyer.
Well, it's funny you should say that. It's actually the very first chapter in my book is why you need a lawyer as part of your business team. I mean, everybody has an accountant, right? Like you need a lawyer like a PC, like your primary care doctor, right? You don't go to the doctor after you have the heart attack. You go to the doctor so you don't get the heart attack. That's why you come to me. Come to your lawyer first so you don't have a heart attack. That's really what it comes down to.
Well, I think that you have really encouraged us all to run out and give you a call.
That'd be great. I'd love to work with people.
Thank you so much for being on the show today. You have
Barbara,
been listening to another episode of Marketing Tips for Doctors. Till next time.
excellent. Thanks, Bob.